Our presenters today are Stanford grads, Michael and Mark Gilfix of Gilfix and Lopole in Palo Alto, California, right in the shadow of Hoover Tower, for those of you who are Stanford alums. This picture is actually of Mike doing a presentation for us in 2011 at the University Club in San Francisco. And so even though we're on this kind of strange format of Zoom, I just want you all to imagine that you are in an audience together and we're watching our speakers, Mike and Mark, and enjoying their presentation. And I wish that we could be, together live, but we're doing the best we can. And
Donna, I have to say the wine and the snacks were better last time, when that picture was taken.
I should have told people this is BYOB.
Yeah, really.
Okay. I am going to stop sharing my screen, and then Mark, if you can share yours.
Yeah, absolutely. Well, thank you, Donna. As we get started, I know that we're kind of inundated with Zoom invites and different webinars we can all attend. So I want us to all take a moment to think about why you chose to attend this. What's on your mind? What are the worries that keep you up at night right now? What are the areas of confusion? Are you worried about your finances? Are you worried about your health, your future, or your family's future, your parents' health, your parents' future, your kids? Do you just feel overwhelmed, as I think many of us do, as we try to navigate this uncharted new world that we're all experiencing right now? I don't need to tell you that we live in unprecedented times. We're facing all kinds of new challenges. One good thing, though, is at least from the legal planning side, the answers to how we can all be prepared, they're already out there. We don't need to change what we do. And at the end of the day, we are here to help. And that's what Mike and I are here to present to you today. It's our goal to break down a lot of the confusing and sometimes overwhelming areas of legal planning to try to make them as simple and as easily executed as possible. So it's our goal today to give you an overview of what you need to be thinking about, documents you need to have in place, the decisions you have to make, and really how you can make sure that you and your family and future generations are covered as we navigate, again, this insane crisis that we're all kind of going through together. So as we get started, we want to start with a mystery. Two guys, Larry and Wyatt. Both of them have a small business, they have savings, they have investments, they both have very supportive families. Larry and Wyatt both have an accident. They're in a car crash. It doesn't really matter what it is. Both of them are incapacitated for 3 months. Larry, while he's incapacitated for 3 months, his business falls apart. His bills are not paid. When he recovers, there's a massive mess waiting for him. Wyatt also is in an accident, also incapacitated for 3 months. During that time, though, his business, unlike Larry's, is well managed, his finances are well covered, his family is able to step in and efficiently help him out. When he recovers, everything is in a good place. So again, two guys in basically the same situation starting out, both get into an accident, both become incapacitated. One comes out of it with a mess, his family is unable to help him. The other one, everything is pretty well handled. What was the difference between Larry and Wyatt and what they did? We're going to uncover that later. So Mike will introduce us to the topics that we're going to cover here today.
Yeah, so begin to think about actually that mystery is great. To kind of keep that in mind as we move along, you can already see, it's planning or not planning. Okay, so today is about planning. It's planning for a crisis, but it's planning that you should do whether or not you're worried about a crisis. So it's just so fundamental, all the things that we're going to talk about. So there are 3 basic documents that we're going to explain in just a couple of moments. And the way you go about that process is so vitally important. So we'll emphasize the talk that you should have. We kind of live and breathe the multi-generational planning perspective. We are a couple of generations. So we cultivate that. When we refer to the talk, we're really talking primarily about family communication. We're going to identify the decisions that you have to make as you deal with these 3 documents that you should have in place. Talk about kind of the logistics. How do you put them into place? What happens? And then if and when a crisis emerges, which is on our minds these days, What do you do? How do you implement them? How do they come into play, and how do they do their work? That's our agenda for the day.
Yeah, for those of you who don't know us, and that's probably most people here, we're just going to add a little bit to the intro about who we are, where we come from, and how that's relevant to what we're talking about today. So we are both part of Gilfix and Lopole Associates in Palo Alto. I'm going to introduce Mike. So I've known Mike for most of my life, well, really all my life, because pretty clearly he's my dad. Mike graduated from the Stanford Law School in 1973. He came from a small town in northern Michigan. He escaped the winters, transferred to Stanford actually as an undergrad. Stanford, when he graduated from the Stanford Law School in 1973, he wanted to change the world. He wasn't interested in joining big law or a corporation. He wanted to help people. He didn't know who he wanted to help. He wanted to find a need, like any good social entrepreneur would. And so he scanned the horizon and he found two critical areas where he saw communities that needed legal help who weren't really getting it. And so he started America's first free legal aid program for the elderly, and he started one of America's first free legal aid programs for Americans with Disability Law Center. In 1973, he started Senior Adults Legal Assistance, SALA. It was the first free legal aid program for the elderly in America, and he really helped to create the field of elder law when he started that, because he didn't just start SALA. He went around the country and trained hundreds of other attorneys to do similar programs, to set up similar programs to get funding around America. So he was directly responsible for creating SALA and serving hundreds of older Americans in the area. But indirectly, I think he was responsible for starting tens of these other organizations around the country and serving thousands and thousands of older Americans. He really helped shape the law as it stands today. He's a national leader. He's published many books. He's been interviewed in national journals. He's appeared in local media pretty regularly. He's dealing with some injuries now. He's a top 5K runner in his age group nationally. At least he was a couple years ago. When his feet heal up, he'll be back. I also point out, so in 1982 started Gilfix and Lopole Associates. He went from the kind of the public world and started the practice that we have today. Served thousands of clients, but during that time, he always somehow found time to coach like all of my Little League teams. And my sister's softball teams and volleyball teams and everything. This is proof. This is the 1990 Palo Alto Little League Outhouse Realty Little League team. I am in the lower left. Mike is the top right. None of us made the major leagues. So if you're looking for a young photo of any future star, there aren't any. Many of them, I'm sure, are stars in their own realms. None of us were that good. We had a good year that year. So Mike's a true national leader and helped shape this area of law. So I learn from him every day. And it's something that we somehow find a way to get along, even through the ups and downs of running law practice together. So without further ado, let me introduce Michael Gilfix.
Thank you, Mark. And Mark, sound is not excellent, I think, coming from you. I'm not sure why. Just maybe, yeah, move closer to something as we proceed here.
Yes.
Okay. So let me introduce Mark. Let's go to the next. Let's go to the next slide. Okay, so Mark went to, let's see, where did he go to school? Oh yeah, Stanford. Mark graduated from Stanford in Management Science and Engineering in 2001. And after he graduated, that was a rough year for getting a job. You might not remember that, but Mark was of the few who landed a tremendous job at one of the top international consulting firms in the world. And he was very, very successful at that, consulting with and advising some of the major corporations in the country and many agencies of the federal government, including the Department of Defense. He was in the venture capital group there, so had a broad experience that just has served him so well as we've moved along. While he was there, he decided after a few years to go to law school and attended Loyola Law School in Southern California. He did that while working full time. He graduated at the top of his class. He was the class speaker. And needless to say, that was a successful experience. Since then, Mark has really emerged as quite a leader. He's won a national award as an author in the field of estate planning, speaking at national conferences, again, really asserting himself and bringing this multi-generational perspective to planners and folks all over the country. And by the way, while he was doing all of that, he was in Southern California, good-looking guy. He ventured into acting for the fun of it, and had remarkable success. He was on a number of television shows, national commercials. There's a show on a movie on Amazon Prime where Mark is the male lead. That's available. You can pick it up anytime. So I had really enjoyed tremendous success. And since this is a Silicon Valley crowd that we're talking with, you'd be particularly interested in something that Mark did. Mark was hired by Apple, and Mark introduced Siri to the entire world. This commercial ran all over the world on television and on computer screens. So 20 million people met Mark, didn't know his name, but here he is introducing Siri. First time Siri spoke anywhere with Mark.
I always feel a need to apologize for any Siri-related issues you've had. It doesn't work well for me either. It didn't work well for us when we filmed that either. They had to kind of fake it off. Anyway. But thank you. Yeah, in the last 6 years, we've been working together on a daily basis. Father, we have a bigger team as well, but it's a fun experience, and it's one that I have certainly learned a lot in the last few years, more than I ever thought I could. And just about our firm, we've been in Palo Alto for 35 years, but we serve people around the state. So especially with Zoom meetings, we're increasingly serving people really from San Diego all the way up to the northern coast. So Mike, why don't you get us back on track?
We'll do. And again, watch your sound, kind of maybe focus on that. Not sure why. I hope mine is okay. All right, so this is a topic for a slide that gets everybody's attention these days. Everybody is thinking about TP. Okay, there's an analogy here. I mean, it's a rough analogy, but there's an analogy here. When you're desperate for it and it's hard to find, I mean, it's worrisome. Same thing, only the consequences are actually much more severe if you're not doing your planning in advance. So with toilet paper, you should stock up. With the planning that we're going to do, I mean, you need to do it. By the way, everybody knows this. At the time somebody will come in, I've been thinking about this for 20 years, 15 years, 8 years, 50 years. So you need to do it. It is fundamental. You got to get off the dime, review what you have or haven't done so far, and take care of business. So that's one of our key messages today. Okay, so what does dealing with a crisis mean? What could come up that could affect you, that could affect anybody? I really think the most important point is that anything can happen to anybody at any time. And the older we get, the more we appreciate that fact, right? So there could be a health crisis. You could have a stroke, God forbid, dementia, some serious illness, obviously COVID-19 could come up. You could be in an accident. We just don't know what's going to happen. Let's face it. So we need to be involved. If you're not involved, if you don't get prepared, if you don't have these documents in place, and one of these things happen, and somebody needs to access your bank account so they can pay your bills, somebody might have to go to court and establish what's called a conservatorship. A judge is overseeing your life. It's expensive. It's intrusive. I mean, no sane person wants that to happen. So our key message, again, we're going to be a little redundant because we got to bring it home. Talk with your family about these things. Make this a topic of conversation. Obviously, talk with an attorney who knows what he or she is doing to get this done properly.
By the way, we're not going to take questions during this presentation, but we're going to try to stick around afterwards. At least I will. Mike might have to leave right at the end. And we will take questions. I think you can submit them via the chat function. So we won't get to everything. We'll see where we are at time. But if you do have questions, please submit them. And also, we're going to provide contact information for our office afterwards where you can send information and talk to us. So what are the big three documents that really everyone should have? It's somewhat straightforward. One is a revocable living trust. 2 is a durable power of attorney for finances. 3 is an advanced healthcare directive. We're going to go into what each of these documents is and why they're so important right now and what you need to think about when you're creating. So a revocable living trust, think of this as what replaces a will. I'll compare this to a will in just a moment. But the key is a revocable living trust, it really needs to be custom to you. Especially if you have kids, if you have grandkids, you don't want to do just a very simple kind of check the boxes type form. There are a lot of tax and control issues. If you own a house, if you're married, if you have younger kids, then there are all kinds of tools we can build into a trust. The key is you don't want to say, oh, I did one 15, 20 years ago, I'm good. The laws changed significantly in the last few years, and it will probably change again in coming years. And you also want to make sure the people you've named as backup decision makers, we'll get into that a little bit more in a moment. You want to make sure that the people named are still the right folks. When we have people who come in who see us, and we'll review their documents, and the first person who is in line to help them out if they need it is someone they don't even know anymore, or they had a falling out with, or they're in jail and they don't trust them. So you got to make sure you stay on top of that, because a properly set up revocable living trust really governs virtually everything you own, and it governs your family's future. We'll talk about why that is just a moment. So I want to compare a trust to a will, because a revocable living trust is what takes the place of what we think of as a will. So why would you create a trust instead of just a will? And will can be okay for some people, but in most cases, it's not the right choice. So if you have a will and you pass away, everything in your estate, even if it says, to my kids, it will eventually get to your kids, but everything has to go through probate. It has to go through the California court system. And this is a very time-consuming process. Right now, probates are on hold because courts are basically closed. If you love the DMV, then you'll love probate. Your family will love probate. It's totally public. So often when you see a celebrity pass away and then you see articles about everything they have or where it's going, you're thinking like, why do I get to know where all of Prince's assets are going and what he had? Well, it's because he didn't have any estate planning documents in place, or because the celebrity didn't have trust. They just had a will. Everything is public. It's only effective at death. So you would name an executor, someone who'd oversee it, but that person can't help you while you're alive. You need to have other documents to empower them to help in many ways. And if you have property in other states, like let's say you have a cabin you inherited in Michigan, like where they're $30,000 for a cabin, you'd have to have a separate court process there. So if you're lucky enough to have any assets in other states, it's really important to have a trust. So having a trust keeps the court out of it. The costs are much lower to administer it. No public access, it's totally private. The administration of a trust is much more efficient. And while you're alive, you can name people who can step in and help manage your major assets becoming incapacitated, which is really important. There's also a lot more tools you can build in. Again, if you have underage kids and you want to build age restrictions, or if you have a complicated plan for what you want to happen after you're gone, you have to have a trust. Now, that being said, wills are not always, sometimes will is enough. If you're young and you have no children, you don't have much in the bank yet, totally fine. If you have an estate under $150,000, that's the cutoff for when probate comes in. So if you have a smaller estate and you don't own any real property, you don't have a house or a condo, then you might not be exposed to probate. Now, if all you have is a will, it's even more important that you have a durable power of attorney and advanced healthcare directive document with that as well. So a will can be okay for some folks.
So let's talk about the other two documents that we've identified as fundamental that you have to have in place. So the first is what's called a durable power of attorney. And the basic idea is you say in the document, you say, look, I'm going to manage my own affairs, but anything could happen. There could be an accident, I could become ill, you just don't know. So I'm going to name somebody who's going to be given authority to sign for me, to take care of things for me. So the idea is, when I name somebody in this document, they are empowered to take care of the business of life, access my bank accounts, act on my behalf, sign a contract for me, stand in my shoes in this respect, again, without the need for court involvement. Critically important is choosing the person who's going to be named in the document. We'll continually go back to this theme. It's just so important to choose somebody you trust, somebody who has capacity themselves, somebody who's reasonably sophisticated, and primarily somebody who's highly responsible. And the documents really should be sophisticated. You can get a 1 or 2 page form. You can check a box, that'll cover some bases, but we're not really talking about, we're above and beyond. And I'm sure the vast majority of those participating in viewing, you're not at the very, very basic level. You have some involvements in business, you have some assets. So you've got to make sure that your document is comprehensive. Okay. We have to say powers of attorney have often been abused in the past. If you pick the wrong person, they have access to your bank account. So again, back to this idea of choosing the person with care, not having the friendly person who drops in, knocks on the door, they're going to help you with the new power of attorney. I mean, you have to be so careful. And it comes down, again, that discussion you have with your family and that discussion that you have with your attorney, who should guide you through all of these points.
And just to the point of abuse, often if you hear of a celebrity who got ripped off by their financial manager, and you're like, how did this some person make off with millions of dollars? Well, it was almost certainly through a power of attorney. They got the right to basically sign on all checks and bank accounts for that person. So again, you have to be really careful with that.
Yeah, we've had to have our litigators in our office fix so many of these situations that it's heartrending. I mean, it is so upsetting when an elder person gives responsibility to someone and then their assets disappear, which we have seen happen. So again, any powerful document has an upside, it has a downside. Okay. So the other critical document, the third one, is the Advance Directive, the Advanced Healthcare Directive. The idea here is you're doing two things. The first thing you're doing is you're appointing the person, here we go again, you're appointing the person who's going to have authority to make medical care decisions for you. And this may or may not be the same person you've named in the durable power of attorney or as your trustee. The trust and the power of attorney deal with the assets and the business of life. With the Advanced Directive, we're in the healthcare decision-making context. Who's going to be with you in the hospital? Who's going to be your patient advocate? Which, by the way, is the topic that we're going to focus on the 14th in a week in a follow-up webinar. Okay. And the other thing you do in this document is you can specify how you want some of the more critical decisions made. End of life. What do you want done? As we did for somebody last week, we have about a page and a half dealing with how their body is going to be cryogenically preserved for that great day in the future when they will be resurrected, or in his words, revitalized. You know, if that's what you want, that's what your document should say. So it's very personal. So again, we're wary of simple forms that don't give you an opportunity to be specific in a sophisticated, careful way. You can write in some vague terms, which can actually be more problematic than helpful at times. So we're a little cautious about simple forms, but you know, we do want to make the point, that's the last in the slide, that these documents are usually available from your healthcare provider. So you don't have to go to an attorney. You can get the form. Usually what they make available is the form prepared by the California Medical Association, by the CMA. It covers the basics. There's a few things in it we would like to see that are not there, but you know, they cover the basics. So at least do that, if nothing else. Staleness. One last point that we have on occasion run into the situation where somebody had their own advance directive and it had some specific direction, in particular about end-of-life decision-making. And the responsible physician is working with the family to figure out what to do, and they look at the advance directive. And it has some directions in it. But the document is 20 years old. And the doctor says, how do I know this is still what that person wants? I served on the ethics committee at the Stanford Hospital for a couple of years, another community hospital, El Camino Hospital near us here. And this was often expressed by the medical providers. You know, they say, we want to know what the patient wants, not necessarily what the patient wanted. So being up to date, making sure that your document reflects your wishes and that you keep it current. A little trick on this, by the way, and we'll probably talk about it next week, is that if you have an older document, it isn't necessary to always prepare a new one. We think it's adequate. You look at the document, if it still reflects your wishes, you take out a piece of paper, you say, hey, I just reviewed my advance directive. It still reflects my wishes, signed, dated, and attach it to your document. It's an issue that doesn't pop up often, but when it does, it can be chaotic and undercut the value of the document. So it's something you have to do, young or old.
And the staleness issue is also a big one for power of attorney documents and for your trust. But keep in mind, a durable power of attorney, we'll talk about how they're put into place, but you are presenting these to financial institutions. So even if you have a well-drafted power of attorney document for finances, if you go to a bank and they see a document that's 20 years old, they're going to be very hesitant to honor that when it comes to large financial transactions. So same point for power of attorney documents. You want to update them every few years. Newer documents can also address digital assets and online accounts in ways that older documents didn't. So, you know, another reason to make sure that everything is up to date, recently updated. So I want to talk about how this is done in a multi-generational way, because we think whenever possible, if you have kids, then you should talk to your kids about this, and you should share copies of your documents. Maybe not the trust if it has specific issues around inheritance that might be touchy. But the power of attorney and the advanced directives, and if you're naming a child as a backup trustee, as a key person in case you become incapacitated, well, you probably should share your trust with them because they're going to see a copy of it sooner or later. If they're ever serving as a trustee, they'll see it. So you should talk to them about it. And if you're not sharing documents, at least talk to them about what it means for them to serve. Or if you're not naming your children, if you're naming a third party, make sure they know that. So they kind of know who to go to and who they can talk to if something happens to them. And whenever possible, if you are working with an attorney, involve your children of the next generation or other decision makers in those meetings so they understand how everything fits together, how the documents work, how you can access them, and what their role will be. It's not, when you start doing it, it's not rocket science, but it can be very overwhelming at first. And there's no reason why anyone would be familiar with the world of trusts and powers of attorney and advanced directives unless they've had a family member who really needed it. So good to have that talk ahead of time. We want to talk just briefly, I will try to get near the microphone.
There you go.
Just briefly about steps you can take to protect your assets for future generations. You don't need to be super wealthy to think about this. If you own a house, if you just have some savings, you want to make sure that they're safe for your kids and your grandkids. There's some very powerful trusts you can create that are not just for billionaires or multimillionaires, although billionaire families have been creating these for a long time. We think every family should at least be aware of it. We'll tell you why Bernie Sanders and some other senators don't think that these should be illegal. It's not a political statement. Some in the Senate and Congress don't think these are fair, but we'll tell you what they do, and you can decide for yourself if you want to create something like this. So a family protection trust, generically known as a dynasty trust, provides some major benefits for the next generation. Again, you do not need to be a multimillionaire to benefit from it. So if you create a trust for your child and you leave assets to a family protection trust, there are three major benefits. So one, if you leave assets to your child through the trust, not to them directly, if they get divorced, the assets you leave them will be safe from a divorce settlement. If they just inherit it and they commingle, that could all be lost. If your child is sued, they're in a car accident, assets in one of these trusts have a high level of protection. There's a barrier that someone has to get through to get to that money. Whereas if you leave it to them directly, that money is fair game for someone suing your child. And when your child passes away, the money that you left them is not part of their taxable estate. So it goes to the grandkids free of estate taxes. Now, currently, you can leave up to $11.58 million to the next generation. That's almost $24 million for a couple, free of taxes. But it's very possible that number could change in the future. In the past, it was as low as $1 million a person, not that long ago. So just imagine if you own a house in the Bay Area or really anywhere in California, you might have to, in the future, if they change laws again, you might have to sell the house to pay the estate tax. This is a way to take it out of that system and protect it. So this isn't relevant for everyone, but if you have kids and if you own a house, this is something you really should at least be aware of. It's a really powerful way to protect assets for the next generation. And your kids, by the way, can be in charge of these trusts. You don't have to have a third-party bank or trustee in charge of it. If you think your child's responsible, they can be their own trustee. So let's talk about the key decisions we have to make. Mike, why don't you talk about how you think about these key decisions?
Okay, and before I do that, actually, I'm going to take Mark's point and make it a little more resolute, shall we say. If you have an estate, if you have over $400,000, you should set up these dynasty trusts. Again, we call them family protection trusts, but you could say they're a good idea, or you could say they're a necessary idea. The wise planner, the wise parent, sets up these trusts for the kids. I mean, it borders on a no-brainer if you think through these examples. And so Mark mentioned the possibility. So somebody passes away today, a single person, they leave $10 million tax-free, because the estate tax protection, again, is way over that amount, goes into this dynasty trust for their daughter, who's smart and lucky. By the time she passes away, it's grown to 30 million, 20 million, 30 million, doesn't matter. The entire amount passes intact to her kids. For us elders, that means it's for the grandkids, the perfect grandkids, right? Because that's really what it's about. So it can save literally millions and millions of dollars for the following generations. So that's why, again, we look at it from the multi-generational perspective. It's something that we should think about as we leave assets to our kids. And if you are a child, as opposed to the parent, if you're listening in and you're younger and you're going to inherit, you should think about talking with your parents about whether they've done this kind of planning for you. Because again, you can control the money you inherit, but it can be protected. And I mean, the divorce rate is still over 50%. It just doesn't seem to waver. So you have to worry about that. Lawsuits are not typical, but we worry about it. You know, look around, there's lawyers everywhere. Look at the screen, there's lawyers everywhere you look. So you never know when that's gonna pop up. So if there's something you can do to protect assets for your kids and grandkids and great-grandkids, it's something that should be done. Okay, so yeah, moving on. Okay, the decisions that you have to make, and again, let's put a little more meat on the bones about your successor trustee. It's real common for folks to say, oh, I'll name my oldest child, just because he or she is the oldest child. That can work, but the primary criterion is singular. Is he or she a responsible person? Your trustee doesn't have to understand the world of finance, but if they're responsible, they know they don't. They know where and how to get help. Money in the trust can be used to hire a financial advisor, for example. So, you know, who's first? The most responsible person you can find. Who's the backup? Because that first person you name, especially if they're around your age, they might not be around when they're needed. So it's not who do you love the most. It's not who lives nearby necessarily. It's somebody who's going to really take that responsibility seriously and discharge that responsibility. If you don't have somebody, by the way, in the family, which is where you first should look, of course, who can be in that role, or a really close friend, I mean, of 30 years, not of a year and a half, you know, somebody you really know and trust, then you can look to the world of professionals. There are individuals who are called private or professional fiduciaries. So they're, as a business, they serve as trustees. They serve as conservators, guardians in the court system. So they're available. Many attorneys serve in this role as successor trustees. Ideally, it'd be somebody younger. Mark has been named by a few people as their successor trustees, because either they didn't have kids or they didn't have kids who were able, or maybe it was a special needs situation where they needed somebody younger who would be around for decades. So it's a tough challenge. This question, who do you choose and to whom do you give responsibility? That can often be a 30, 40-minute discussion in an hour-long meeting. I mean, it can be, again, if you think about it, your life in many ways are going to be in the hands of the individual to whom you give these responsibilities. So you take it seriously, not a casual decision. And you know, all of these documents, by the way, you can change this at any time. So again, you think of who's going to make healthcare decisions for you. Sometimes a family member is not the right person. They might not be able to follow your wishes because they're uncomfortable with them. They might have religious views that are different than yours. And again, we've seen a lot of family conflicts at the end in situations like this. So we just can't overemphasize the importance and sometimes the difficulty of choosing somebody who's going to be your trustee, named in your durable power of attorney as the attorney in fact, and who's going to be named in the advance directive in that healthcare decision-making context.
So how do you actually put these documents into place? What are the steps you have to take? You really should meet with an attorney. Absolutely. You don't need to meet in person. We serve clients throughout the state. You can do it via phone call or Zoom meetings. Documents, drafts can be sent as PDFs. Eventually you need hard copies. You really should make the decisions with some expert guidance, especially if you have kids. If you have any kind of complications in your family, you need expert guidance to make sure that your choices are done properly and the documents are done right. And there are the three big documents. There's a trust, and when you create a trust, there are some supporting documents. There are pour over wills, certification of trust. So I'm kind of oversimplifying that a little bit, but you'll get that package of documents you'll be signing. You get the power of attorney, the advance directive. You approve them, and once you feel good about them, you sign them. They do require notarization. You can do that remotely. I think the state may make it easier to do that digitally, but right now you can't DocuSign a trust, or you could, but we can't guarantee it would hold up in court if you just DocuSign. You really do have to notarize them, unfortunately. And then ideally, you should share them with your family. Maybe not everything about where you're leaving your assets, but certainly who you're naming and how you've generally structured things. You should talk to your kids. The old idea in movies where someone passes away and they open the safe deposit box and then they do the reading of the will. That is an antiquated way of looking at it. In some families, you can't share these things. We get it. There's some situations where it's tricky, or you don't have kids and you're not sure who to share it with. You know, that can be dicey. And if you don't have kids, share your documents with the people you name. Make sure that they're they're aware of how everything works. Now, how are these used in emergencies? What do you do? If something happens to you, how do these documents help you? Well, in a trust, you name successor trustees. And these are the people who can step in if you're incapacitated. So one way is if you are sick or you just can't manage things anymore, you can just voluntarily resign, let your successor trustee know, they sign a document accepting the role. As trustee, they step in and they manage your day-to-day trust affairs and your financial affairs. Alternatively, if you don't voluntarily resign and you're in an accident or something happens to you, then a doctor's letter showing that you're incapacitated. A physician says, if something happened to me, Mark Gilfix, as a result of an accident, it cannot manage his finances and is incapacitated. You present that note with the document, and then the next person in line can step in. For the durable power of attorney document, it's the same steps. You can voluntarily give someone else power of attorney from day one, or you can have the document set up so the person you name can only step in if you're incapacitated. Now, it is important to get copies of that document to your bank, to any other financial institutions, or even government agencies that you're working with, like the Social Security office, if they'll accept it. Make sure they have copies of these ahead of time, so if something happens, you don't need to frantically search and send them to them. Advanced directives. Similarly, get a copy to your doctors, get a copy to your medical providers, and make sure you have extra copies of all of these documents in your home as PDFs, so your family easily has access via email and can print them out. If you work with an attorney, hopefully your attorney will keep backups of all documents. We do that for all of our clients. We keep scans of all documents. So if they need them, we can email them. You know, what could a crisis be? It could be anything.
You never know. And that's probably our main message here. We've already gone over this to some extent, but you know, again, you just got to keep these things in mind. You can't hear it enough. Once you sign all your documents, then maybe you can stop listening to some of these points, but you need to. Okay, stroke, dementia, something debilitating, an accident, in a way those are obvious. Long-term care. What if, as a result of some physiological or mental issues that arise, you're not going to be able to take care of yourself at home? That's actually the third webinar we're going to present. So in a couple of weeks, we're going to be focusing in on that. And we want you to know that Mark and I actually co-authored a book. You see at the bottom, Facing the Reality of Long-Term Care. And it explains the alternative ways you can pay for the cost of care, government programs that are available. Medi-Cal can pay nursing home bills, for example. Assets can be protected and you can qualify. So the way these things fit together, by the way, is if you should become incapacitated and there's a need to plan proactively to rearrange assets to protect them and qualify for these programs, the durable power of attorney has to be explicit in giving that authority. That goes to the point about the need for a sophisticated document that isn't just check the box. Check the box powers of attorney don't work when it comes to some of these more sophisticated planning needs that someday you might have to address at some point. And let's face it, another family crisis is if there's a divorce in the family or somebody gets sued. We address all of these points directly or indirectly in the planning that we do. We've covered these points. And you know, on COVID-19, again, how many of us have been thrust into this reality, or at least the fear that we're going to face a crisis? And by the way, we want you to know that we, in our office, we put together a program that we call Docs for Docs. Documents for doctors and other first providers. So for no cost at all, we're actually doing powers of attorney, advanced directives, and wills for first providers, for folks on the front lines in the medical care context. So you know, we're practicing what we speak, what we preach here, in the context of, you know, just fundamental planning, making sure that you have a plan in place. So we want you to, you know, just drink in these points, understand the need, It can come up in so many different contexts. By the way, I want to add one other. Years ago, our Mark's younger sister of the two, was traveling. She was in the jungles of Ecuador on junior year abroad, couldn't be reached. A form came in the mail for her insurance, and she had to sign it to keep her insurance active. She couldn't be reached. When all of our kids hit age 18, we had them sign power of attorney and an advance directive. I was able to sign the insurance form for Janie. It wasn't a crisis, but it shows the practical use. You could be traveling, simply traveling and incommunicado for some period of time, and the durable power of attorney or the trust, vital document. So get a sense of get a sense of how valuable and how practical these documents are. That's what this is about, just like reality, real life stuff.
Yeah, and actually, Mike, I just want to expand really quickly. If you are a first responder or a doctor or a nurse dealing with this crisis, we are offering free basic estate plans to you if you don't have any documents in place. So contact us if you fit that description. You're helping it. We want to help out the people who are putting themselves on the line. So let's talk about let's go back to the mystery that we talked about at the beginning, Larry and Wyatt. Both of them have some savings. They have supportive families. I'm trying to speak up. I understand there's some trouble hearing me. I'll use a better microphone next time, I promise. Both of them have an accident and are incapacitated for 3 months. Otherwise, very similar situations. They have supportive families. They have some money in the bank. But when Larry comes out of it, his business has fallen apart. His finances are a mess. His family's had to go to court. Wyatt, on the other hand, it wasn't that bad. His family was able to help out. His business was managed. His finances are okay. What is the mystery? What's the difference between how they dealt with things? Well, it goes back to what they did ahead of time. Larry didn't do anything. He had no estate plan in place. He had no trust. He had no power of attorney. He had no advance directive. So no one in his family was empowered to step in and help. When they tried to access his bank accounts, the bank said, sorry, you're not on the account. So they had to go to court. They had to get a conservatorship, and they had to spend thousands of dollars in legal fees to help manage his affairs. Whereas Wyatt, he had the trust, he had the power of attorney, he had the advance directive. So his family could pretty seamlessly step in to manage his finances. The bank already knew that they were empowered to help out. It's a lot easier. So setting these documents up ahead of time can be critical. It can save thousands of dollars and hours and hundreds of hours of wasted time dealing with messes. So again, planning ahead is key. So what can you do to protect your family now? Well, I think there's first overcome the danger of denial. We hear this all the time, the people that came to see us and they started thinking about this 5, 10, 15, 20 years before. They're like, I won't get sick. I'm going to be one of the few who never get sick. I'll get to it next year. I'm not going to need long-term care, and no one in my family is ever going to need a nursing home. Hopefully that's the case. But over 70% of Americans are going to need some form of long-term care. That's going to be a subject of our third talk, by the way. Or I'll live forever. I don't have to think about planning for future generations because I'll be around in 2086 and 2095. Or I'm good. I already created my plan. Yeah, it was 10 years ago, but I'm sure it's fine. So take a fresh look. Make sure that your documents are up to date. But having an old plan you haven't thought about in years, in some cases can be worse than no plan if you have the wrong people named and the wrong plan in place. So I think 3 documents, I want to revisit these, by the way. Trust, power of attorney, advance directive. I have a public Facebook channel, and I have a goofy video where I just repeat these: trust, power of attorney, advance directive. These are the 3 documents you need. If you're young and you don't have many assets yet, or if you just have a very small estate, a will might be okay. But you absolutely need the power of attorney, advance directive. And if you have kids, you really need the trust. So we want to just make a special offer. We've gone through a ton here. We are happy to spend 15 minutes with you at any point. If you want to set up a Zoom meeting or a phone call with us for anyone who attended this, email or call us. We're going to provide contact information here. And also, I think Donna will send out some information to get a hold of us. No strings attached, free 15 minutes with us if you want to chat with us after this. You can follow me on Facebook if you want to see my goofy videos. Facebook.com, Mark Gilfix. And here's some information about how you can get in touch with us. Again, we are happy to chat with you, to answer questions, and to go over any follow-up issues you want to address at no charge for people who attended this. So just let us know. You can call our office. You can reach Ashley on our staff because we'll be handling this, but Donna can help to share this afterwards as well. And as we wrap this up, I also want to remind you again, I think Donna, you put these dates up, but we're going to be doing 2 more webinars for this audience. So the next, and my mother, Myra Gerson Gilfix, who is an expert in this area, will be taking part in the next one as well, medical decision-making and patient advocacy. So how do you make sure that if you have to go to the hospital, someone is there and can communicate on your behalf? And very importantly, what can they do to make sure you stay safe in the hospital? Medical errors in hospitals kill hundreds of thousands of people every year. I've learned a lot about this recently. It is critical to have someone there. How can you empower them and what can you talk to them about? And on the 21st, 2 weeks from today, we're going to be offering a multi-generational planning as it pertains to long-term care. We're going to talk about how you can preserve your house, your other assets, while getting help to pay for long-term care, and how the whole family can be involved. You can register. The addresses that Donna can send to everybody. And again, the 3 documents: trust, power of attorney, advanced directives. We live in crazy, uncertain times. This is one area where you can take some control and embrace this as an opportunity to bring your family or your loved ones together. Because when you create these, I think it can be very freeing. It takes that weight off of your shoulders, and this thing is always in the back of your mind, and you can kind of put it out. So get this done. If you did a plan a long time ago, take a fresh look. We are, of course, available as a resource to help you if you'd like, but get back into it. Talk to your loved ones about this. So I hope you got a lot out of this. We're going to see if we can answer some questions, but Donna, I'll turn it over to you.
Okay, and before I unmute everyone so that we can give them a well-rounded applause, I just want to let you know I have been monitoring the chats, and I know many people have asked if this would be recorded and posted somewhere because you want to share it with friends. So I will be working with Mark and Mike to see if we can master the technology to get that online for you. So I will be sending out an email. It will have the links. It will have Mark and Mike's offer if you want that 15 minutes to talk with them and ask them questions. And now I am going to push the button to unmute all so that we can do a round of applause. Oh, wait, sorry.
Are there any, if anyone wants to submit written questions too, we're happy to go through that.
Okay, and now let me just do a round of applause so that those who need to get off the line can. Stop.
Try to line up with the investor-led onboarding project and to line up with
if you have questions, you can unmute yourself and ask them, and I'm also going to try and get the chat working so that people could there, and you can also post them on the chat if you wanted to stay on and have any specific questions.
I have a question.
Rainbow?
Hi. What was the dollar amount for when you want to switch from a will to a trust? Because I wrote it in the chat. I don't know if you saw it yet. But as a solopreneur who doesn't really have assets at this point yet, I think the will and the durable attorney and the directive, but when do you switch from will to trust?
Yeah, the dollar limit, and Mike, you're muted by the way. The dollar limit is $150,000 in California. If you're under that, even if you just have a will, you're not exposed to probate. If you own any real property though, even if it's worth less than that, you would still have to go through the court system. Generally though, as an entrepreneur, hopefully you'll have a very prosperous future. So it's usually a good idea to set up a trust regardless, just because once you have it there, you're good in the future. You don't have annual fees for it or anything. So generally speaking, it's a good idea to have a trust regardless. But in the near term, you're under that limit, which many of us are, paying off student debt or things like that. You wouldn't hit probate if something happened to you while you're still under that asset.
Under 150,000, you don't hit probate. Yeah, I'm just thinking about, where do we use our time and energy? I'd rather make sure I help my parents and make sure they're set up, because they do have assets, and I want to make sure that's handled before we worry about me. So thank you. This is really helpful.
Could you hear Mark? Could you hear Mark clearly, Rainbow?
For the most part, I got the most of it.
Yeah, it's not good, Mark.
Next time.
Yeah.
I will. Yeah,
Yes,
thank
Chip?
you, Rainbow. Any other
Yes.
any other chat questions?
And
Oh.
Samsung, could you state your name and your question?
Oh, sorry. It's Edith Kaplan.
Hi, Edith.
Hi. First of all, hello to Michael Gilfix. I don't
Edith,
know.
hi there. Wow.
Remember me from the old days?
God, I do. How about that? A couple of veterans here.
I know. Well, I probably will call you for a 15-minute, but the short question is I'm single, no children. Is the Dynasty Trust only for children, or would my niece and nephew fit under that as well?
Yeah,
Great
really
question.
good question. Yeah, definitely for niece or nephew. It's really generational. So it's
Uh-huh.
not at all, and actually one of our clients set one up for a godchild. So yeah, absolutely, same exact thinking. And if you
Okay.
do that, by the way, your niece or nephew's parents obviously should be part of that planning. So if you set that up, assuming you guys agree on the trustee and things like that, everybody could use the same dynasty trust.
Well, the parent is my sister, who's 8.5 years older and doesn't want to be included. She
You
has
can
her
do
own.
it. Short answer, absolutely, yes, with all the protections, yes.
Okay, good to know.
Lucky
Thank you.
niece coming up here.
Yeah, but other people can't. See, I want to leave some to a friend as well, so that would
Sure.
not be possible, yes?
Absolutely.
Donna, any other?
Thanks.
Lucas?
Can I build on that? This is Lucas. May I? Donna? Yes.
Yes,
Thank you.
please.
Great presentation. Thank you very much. First time myself, as you can tell from the accent. Thank you. As you can tell from the accent, I'm not from this country, so all this is really new to me. First time I realized that there is a separate distinction between the family, the generational trust, and the recoverable trust. Can you clarify, do we need both, or the one is a superset of the other?
So,
Otherwise, we can take it offline over the 15-minute special you said.
yeah. So I think the question was about the family protection trust, and if that's separate from a living trust. We're having a little trouble.
May be interesting for others.
Yeah. So really,
Correct. And if it's it's the connection. Correct. And if it's a superset, if the superset of the other. So if one has the one, doesn't need the other, and so forth.
yeah. So I think we're having some trouble hearing you. So I'm going to answer what I think I heard, and I apologize if I didn't get the right question down. You can contact us and we can clarify more. But I think the question was if you create a family protection trust for the next generation, is that separate from your living trust? And the answer, I'll get to my phone. The answer is that they are separate. So you create a living trust for you and a separate family protection trust for the next generation. If I didn't hear that question properly, I apologize. And I don't know if you can hear me.
Yeah, let me, that was hard to hear. So if you have a kid, let's say you have one kid or a niece that you're thinking about, you do your revocable trust. It holds your assets. You title your assets in the trust. You manage them as long as you live, the assets stay in the trust. Upon your passing, the assets go into the dynasty trust. We create the dynasty trust at the same time that you create the living trust. They are two separate trusts. So it's sitting there waiting to be funded in most situations. So short answer, they are separate trusts. They work together. So they are created at the same time, at the outset.
And then I have got a question for you guys from someone who would like to know, does the Dynasty Trust cover children who were adopted out of family? Are they eligible for inheritance?
Oh, I'll answer it. Yeah. Again, it can be the next generation age-wise. So in Edith's question, it was a niece. In the example I gave, it was a godchild. It can be anybody you choose in the next generation. And there's something we'll get into it now, GST, it's called Generation Skipping Transfer Tax. So it's generation skipping planning that we're talking about here. Usually it's for the kid, but it can be for somebody who's not your child or who was adopted out. Absolutely.
Yeah, and I have a written question, a good one. So the question is, I set up a trust 14 years ago. assuming that I am still happy with my chosen trustees and the plan distributions, what laws have changed since then that would make a revision or amendment wise? So one big change in the last 14 years was the estate tax exemption amount. So the exemption, the amount that you can leave to the next generation without tax exposure, has gone up dramatically. So even just a few years ago, until the recent tax bill was passed, it was about $5.5 million you could pass per person. Now it's 11.58 million per person. So even if you don't have a large estate, your previous trust might have been set up with protections you don't need. So unless you have a very large estate, you're not going to face any estate taxes. There are different capital gains tax issues that affect couples especially. That's not the core subject of this talk, but the big change is the estate tax exemption amount has changed, and that has big implications for how your trust might have been set up 14 years ago. It might build in a bunch of protections and unnecessary complications that you don't need anymore. So that's one thing. Another thing is digital assets. So California passed a law giving the people you name as backup agents the ability to access digital accounts, which can be really important. The document 14 years ago isn't going to address that. So those are just a couple issues, but definitely a good idea to take a fresh look.
Yeah, I think the important point there is it's 14 years old. Many laws have changed, as Mark said, so it needs to be reviewed. Us or some, whatever attorney you choose, but it really needs to be reviewed, get it up to date, so it's as efficient as possible and captures all the protections that you need. It evolves. It evolves.
So I think maybe Donna will give you one more question, and we have to hop off. But any other questions? Are we good?
Hold on.
Good.
I'm sorry. I have one. I'm sorry.
Oh, great.
Hi. I know that 10 years is too long. When is the best amount of time to update those documents?
Update.
Oh.
There's no right or wrong answer there. But Mike,
okay. If you have a plan in place, you at least think about it every 2 years. You revisit the trustee. You revisit the bequest or distribution plan. Are you now thinking about a charity that you weren't before? Are the terms of your advance directive accurate? So that doesn't mean you have to change it every 2 years. We have a plan where we stay in touch with our clients every year. They have a free hour. So people, just check in. Often they make no changes, but they look at it. They make sure they're comfortable. They sleep better at night. So at least every 4 or 5 years, ideally every 2 years, you really should check it out. Law changes in the family, your thinking might have changed, and your trust may have provisions you don't even remember that they're in there. So check it out.
Yeah,
Thank you very much.
Thank you. The people you name are everything. They have a lot of power. So if those choices are not optimized, that can be a big problem. So really important to revisit your backup trustee, backup agent choices.
Okay, and on that note, I again want to thank Mike and Mark and all of you for joining for this really important topic. And again, remind you on May 14th, we will be doing one on medical planning, and then on May 21st on long-term care planning. For the Stanford alums, you can do that through the Stanford alumni. Stanford Club of San Francisco has the registration. If you are a Next Village member or a guest, I'll send you those links. So again, thank you very much, and I'm unmuting everyone so that we can give a round of applause to our presenters. Thank you very much.
Thank you, and happy to chat with people if you'd like. Donna will send out information about how to get a hold of